And Mr. Chair, welcome back to the Senate Committee on Judiciary, and we'll give you a few minutes to get settled, and you can begin when you're ready.
Good morning, Madam Chair, Assembly District 9 in Southwest Las Vegas. It is a pleasure to be here with you this morning, and in fact, I got out of one of the hearings we're doing in Assembly Judiciary right now, so I appreciate the invitation to be here and to present Assembly Bill 424 to you. Assembly Bill 424 is one of the few bills that we do pass without any amendments, so if you have the original version in front of you, that is the one that we'll be working with. With me to my right is James Dold, who I know you've heard from earlier this morning. He's here to help me present the bill, and I believe on the phone we have Sarah Cruz on as well, who would tell you a little bit about her story if she hasn't already. There are others in Las Vegas, as you can see, who'd like to testify, including Ms. Wildevelt and Ms. Rasmussen. We really can't talk about Assembly Bill 424 without first talking about Assembly Bill 267 of the 2015 session of the legislature. For those of you who were here in the building, either as legislators or otherwise, you may remember Assembly Bill 267 from the 2015 session. Those who are with me here today and who I introduced were individuals who helped pass that bill in 2015, and that was a bill sponsored by then Speaker John Hambrick, by a tally of 63 in favor, 0 opposed. I had the honor of working on that bill, not as a legislator, but as a lobbyist, and I had hoped that Assemblyman Hambrick would be able to join us this morning from Las Vegas. Unfortunately, he was not able to join us, but I suspect he may be watching, so I wanted to say hello to him and thank him for his work on Assembly Bill 267 of the 2015 session. So before I get to the new bill, what did that bill do in 2015? It did something critically important. It provided hope. It provided hope to individuals who had undoubtedly committed very serious crimes as juveniles and received life sentences or the equivalent of life sentences at the time they were sentenced. These were individuals who were functionally sentenced to die in prison for things that they did when they were not yet adults in the eyes of the law. Assembly Bill 267 of the 2015 session provided that anybody sentenced for a crime committed as a juvenile that did not result in the death of a victim was eligible for parole after 15 years. It had eligibility after 20 years if there was one death that occurred because of the criminal activity. Again, parole would not be mandatory, but the person would be eligible to go before the parole board. That particular legislation, however, did not provide that same opportunity to anyone convicted of a crime where more than one death resulted. This has resulted in some odd outcomes in our judicial system. Instances where you have co-defendants in the same case, where one co-defendant has already been released because they pleaded guilty to one death, and then another co-defendant with virtually the same conduct will never be released because their particular charge carried 2 deaths. Ms. Wildevelt will tell you more about that scenario in a moment because it actually has happened in one of the cases here in the state of Nevada. So the bill in front of you, Assembly Bill 424, makes anybody sentenced for a crime committed as a juvenile eligible for parole at 20 years, even if there was more than one death that occurred. And again, I want to emphasize, we're not talking about mandatory release. We're talking about eligibility. The parole board would still go through its normal process, assessing risk, hearing input from victim and victim's family members before deciding whether release would be appropriate. In my view, there was no logical basis to exclude the 2 or more deaths in the original legislation from 2015. As you're going to hear from Mr. Dold, and you probably heard some already this morning, juvenile offenders are unique in their ability to be rehabilitated. He'll discuss some of the brain science and some of the legal opinions. To be clear, the individuals that this bill would apply to committed egregious crimes. There's no doubt about that. But keep in mind that they were committed when they were juveniles, and this bill merely gives them the chance at parole. It doesn't guarantee it. That would be entirely in the discretion of the parole board. Hope is a powerful thing, and we have the power to give that hope with Assembly Bill 424. I anticipate that you might want to know how many imprisoned people in Nevada this bill might apply to. It's hard to know for sure, but our best estimate is 8. 8 people who continue to be excluded under the 2 or more death exclusion in the law. 8 adults who are now in prison and have been in prison for quite some time, who will functionally spend the rest of their lives there for crimes committed as juveniles. Those are 8 individuals with little hope of ever being released. And in addition, they are often ineligible for programming because programming is going to be preference to somebody who might actually get out of prison one day. So with that, Madam Chair, I would like to turn it over to Mr. Dold for some additional remarks, and then whenever you feel it's appropriate, we can take questions.
Great. Thank you so much, Madam Chair. James Dold, again, for the record, representing Human Rights for Kids, a DC-based human rights organization dedicated to promoting and protecting the human rights of children, particularly those in the justice system. Let me just first note and thank the Assemblyman Yeager for his leadership in introducing this bill, and Assemblyman John Hamm leading the effort to reform the way that our justice system treats children here in the state of Nevada. This is a really important issue. And I've talked through some of these dynamics, and so I won't belabor many of the points too long, but I thought it would be helpful for the rest of the committee to kind of get a little bit of a history, both on sort of how we got here as a nation, and then also some of the legal dynamics regarding the opinions when AB 267 was passed and why some of those exceptions were made in that bill at that time. So back in the late 1980s and early 1990s, there was a juvenile crime wave that happened. And there was a group of criminologists who theorized that there was a new group of super predator children who were coming of age who were more violent and less remorseful than ever before. These children were characterized as being godless and jobless and fatherless monsters, and states were urged at that time to pass laws making it easier to transfer children into the adult criminal justice system, opening them up to extreme punishments like the death penalty and life without parole sentences. At the same time that that is happening, we're also seeing things like the advent of the 1994 Omnibus Crime Control Bill, as well as the increase in mandatory minimum sentences all across the country. And so children were really exposed to lengthy prison sentences. And so about 15 years after this begins to happen, the U.S. Supreme Court begins to weigh in on the constitutionality of these decisions. We spoke earlier about the juvenile brain and behavioral development science, which really underlied these decisions by the court. And Justice Kennedy, in 2005, authored the opinion of Roper v. Simmons. And in that case, the Supreme Court, relying on that science and on the international consensus against the use of the death penalty on child offenders, ruled that sentencing a child to death violated the Eighth Amendment's prohibition on cruel and unusual punishment. This really kicked off the beginning of what we call the kids are different jurisprudence doctrine, and that carries over 5 years later into a case called Graham v. Florida. In that case, again, relying on the juvenile brain and behavioral development science, and again in an opinion authored by Justice Kennedy, the court specifically found that life without parole sentences violate the Eighth Amendment's prohibition on cruel and unusual punishment for children convicted of non-homicide crimes. In that case, the court likened life without parole to the death penalty for children because no matter how much a child changes, no matter how much they're rehabilitated over time or express remorse for what they did in their youth, they will never leave prison alive. They will essentially only leave prison in a coffin. And in that case, the court said that states must provide child offenders with a meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. 2 years later, in a case called Miller v. Alabama, the court struck down the use of mandatory life without parole sentences for children even convicted of homicide-related offenses. What's noteworthy about that case is the court specifically said that before a child can be sentenced to life without parole, sentencing courts must consider the mitigating factors of youth prior to imposing the nation's harshest possible punishment. Now, at the time that Miller was decided, there was a little bit of a split on authority on how broad that decision actually was meant to be. But we got a little bit more clarity in 2016 when the court came down with Montgomery v. Louisiana. Now, prior to Montgomery, the Nevada legislature during the 2015 legislative session passed AB 267. So as we were going through the process of negotiating that bill and putting all of the different dynamics in play in terms of parole eligibility and which provisions would apply retroactively and which wouldn't, that was sort of a consideration because we didn't have the guidance of the Supreme Court, which they handed down in the Montgomery decision. So in Montgomery, in 2016. The court ruled a couple of important things. One, that the Miller decision was in fact retroactive, but the court actually broadened the scope of that decision and basically told courts and legislatures across the country that we had previously been misinterpreting what Miller stood for. Many people thought, or some people thought, that Miller only applied to cases involving the use of mandatory life without parole. But the court actually deemed that was actually wrong. And I'm going to read a couple of quotes from the decision because I think they're relevant for this conversation. Specifically from the decision, the court noted, Miller determined that sentencing a child to life without parole an unconstitutional penalty for a class of defendants because of their status. Even if a court considers a child's age before sentencing him or her to a lifetime in prison, that sentence still violates the Eighth Amendment for a child whose crime reflects unfortunate yet transient immaturity. The court went on to explain that the Miller decision was very much like the Graham and Roper decision before it, the one distinction being that they left open this small sort of carve-out window where a child potentially could receive a life without parole sentence if the state could show that a child was permanently incorrigible or beyond rehabilitation. Now, that's a standard that we believe can't be met because we don't know who a child will be 15, 20, 25 years down the line after they've had time to mature while they've been incarcerated. In my written testimony, and I'm not going to belabor this during my spoken testimony here, but in my written testimony, I go through some of the different state Supreme Courts that have taken up the interpretation of Miller and Montgomery after the Montgomery decision came down. And I'll just highlight a couple of those states. These include the Supreme Courts from the states of Georgia, Oklahoma, and South Carolina. Certainly not a liberal bastion of jurisprudence by any stretch of the imagination. And all three of those state Supreme Courts have found that even though their states had discretionary life without parole sentences, just like here in Nevada, that Montgomery and Miller were still applicable to them. So that's really important to note, and I'm happy to go into further detail, and I also have those cases for anybody that's interested in taking a look at them. But it's a really important understanding because before, when we were working on AB 267, we didn't have the guidance necessarily from Montgomery to fully acknowledge and understand the import of that decision on the state. And so because of that exception in AB 267, the carve-out exception, there are now 4 individuals who are serving life without parole sentences that are very much in violation of the Eighth Amendment's prohibition on cruel and unusual punishment. AB 424 will alleviate the need for any unnecessary litigation in this area and basically put on par those individuals with the other individuals who were impacted by AB 267. I think it's important to note that all across the country, states have grappled with how to not only interpret but also implement these Supreme Court decisions. And through legislative enactments like AB 267, by state Supreme Court decisions, 21 states and the District of Columbia have all banned the use of life without parole sentences, in many instances also giving individuals retroactive parole eligibility. Over 500 individuals who were sentenced to life without parole for crimes they committed as children. And when I say crimes, I'm referring specifically to homicide offenses. In many of those instances, too, sometimes you're talking about one victim, sometimes you're talking about 2. But in those instances, those individuals have been given a second chance, an opportunity to come home. And there's over 500 of these individuals who have been released across the country. We have a 0% recidivism rate of all of those individuals, including here in the state of Nevada. I think we have about a 50% parole release rate. So a number of individuals have also been home for a number of years, have not recidivated, have been tax-paying citizens, have been doing great things in the community to also keep children out of the justice system. And so it's really important to highlight that, these aren't kids that, cannot be reformed and cannot be rehabilitated. Certainly there are some individuals who should never come out of prison, and we need to acknowledge that. But what AB 424 does is just what AB 267 does, which is give the parole board the opportunity to review these cases and make a determination on whether or not they have been sufficiently rehabilitated, whether or not they pose any danger to the community, and if that is not the case, and if they have been rehabilitated, to give them the opportunity for a second chance. And I'll just close my testimony by saying that, there's a lot of different ways to look at this issue. You can look at this through the legal lens, which I've just laid out through the U.S. Supreme Court cases, and why this is important to keep the specter of litigation outside the scope of what Nevada will have to deal with if nothing is done. But there's also the moral lens. And, when we talk about living through our values, I'll highlight something that was said by former U.S. Senator Alan Simpson, who many may remember served in leadership under Bob Dole in the 1990s. He recently eulogized former President George H.W. Bush. He's written a number of op-eds across the country in support of giving all children the opportunity for a second chance. And in these op-eds, he oftentimes cites to the examples of Moses, David, and the Apostle Paul, who were all guilty of killing, yet went on to serve God in very significant and important ways. And he always closes these op-eds by saying that if our children are not deserving of our mercy, then who amongst us is? And with that question, I will be happy to yield for any questions.
Thanks, Madam Chair. I was pretty involved with this in 2015. So I'm more curious about you said 500 people have been released since when, approximately, and zero recidivism rate. That's very, very impressive.
James Dold again for the record. Senator Hansen, yes, and thank you so much. You were the Assembly Chair when that bill was being heard. Yes, across the country, the numbers vary from state to state. I think the largest portion of individuals we've seen released has been in Pennsylvania, where they've released upwards of 200 individuals. They also had the highest number of individuals serving these sentences prior to the decision coming down. So that goes back to dating back to 2012 when the Miller decision first came out. And it was kind of a trickle effect. Some states began implementing these changes very quickly. Others were slow to go and needed the Supreme Court decision in Montgomery before they really got rolling on some of these releases. But yeah, all across the country, we've seen really seismic shift in the way that people think about how we incarcerate children and the need to treat them differently in the justice system. Here in Nevada, I don't know the direct number of individuals. I just know that there's been roughly a 50% parole rate of the individuals who've been released. I've been on Facebook with many of them. They call me. I talk to them over the holidays. They've gotten married. One individual who was 15 years old, who was sentenced to life without parole here in the state, is actually living in Illinois now. He recently got married. His wife is pregnant and is expecting his first child. And so they're getting to experience all of these things that they never thought they would get that opportunity to have in life. And it's really important that we recognize that when we're dealing with children that we need to treat them differently. But it's been an incredible thing to see, the fact that there's been no recidivism by any of these individuals who've been released. And so we think that the parole boards are fully equipped to handle this and make the determinations of who should get out and who needs to stay in prison.
One follow-up, I could, Madam Chair. The victims' families, the people whose children were murdered by the children, basically, I would assume are adults. What's the response been typically? Because right now you obviously get to go before the parole board. Currently, these people would be considered incarcerated forever. When you bring the families of the victims back in, what has been the response overall? I mean, you got to serve at least 20 years and so forth. I'm just more curious about that side of it too.
So James Dold again for the record. I can speak a little bit nationally. Victims, I think, they're not a monolithic group, and so they have a lot of different opinions and views on this. Sometimes, they're very upset that they have to go back into court or go back, before parole board because they thought there was going to be finality. In other instances, what we've seen is sort of this process of restorative justice where they come back in and they've forgiven these individuals and agree and ask the parole board to release this individual. One woman, I'm always amazed by their incredible grace. One woman named Dorothy Holloway, who I've worked closely with in Arkansas, her son James was killed by a 16-year-old boy, and she has been fighting for him to get a second chance. She's gone to the parole board. She's actually gone to the governor of Arkansas trying to get a commutation for him. They write letters. She very much considers him, her adopted spiritual son. So it's and obviously the grace that's portrayed in that is incredible. But there are people on the other side too, where these wounds get reopened, and it's a very difficult thing. And so, and that's what we're trying to do here: sort of come up with a semblance of justice through balance, and trying to figure out, what's the best way to do that. But we're definitely very sympathetic to the plight of victims in these cases, and think that they need to be provided with all the resources and services that they are deserving of as well.
But obviously these do go before parole boards who take those kind of things into account. I just think the only downside of this is that the victims' families, in fact, do get drugged back into the system when they thought that it was finalized. But you mentioned that there are people that qualify, but in fact are left in because they are essentially not the type of people that we want to let out on the streets. A percentage, I'm curious as to, you mentioned 500 getting out of what, 2,500, so, one out of five actually been released, or is it substantially higher than that? I'm just kind of curious on the stats on that side of it.
Absolutely. James Dole again for the record. Yes, so for the people that were serving life without parole for homicide-related offenses, there were about 2,500 nationally. About 500 have been released. I don't have the exact number.
20% roughly.
Yeah,
Okay.
just released, and then many of them have been either resentenced or through legislative enactments been given parole eligibility but haven't been released yet.
Okay, very good. Thank you, Madam Chair.
Doesn't look like we have any additional questions, so thank you for the presentation. We don't look like we have anybody else wishing to testify. Mr. Chair, if you would like to give any closing remarks, we would offer that to you.
Thank you, Madam Chair, members of the committee. Steve Yeager for the record. I know it's been a long morning. I want to thank you for your attention to Assembly Bill 424. We call our prisons Department of Corrections, and we do that for a reason, because the idea is that if we do it right, there are behaviors that will be corrected and that you can come back into society. In this case, I think corrections really applies when we're talking about individuals who committed crimes, juveniles, individuals who are going to spend at least 20 years there and perhaps a lot more. But we want to give every incentive to those individuals to actually correct what led them there. And I think Assembly Bill 424 does that, because when you have two different outlooks, one being I might have a chance to get out someday, and the other being I'm going to die in this facility, what we do there is we give hope. We give hope to those to someday get out and be able to make some kind of life for themselves. So with that, Madam Chair, members of the committee, I urge your support of Assembly Bill 424.
Great, thanks. We will go ahead then and close the hearing on Assembly Bill 424.